Okay, anytime we have any actual ordinance changes, we have to have two public meetings, and we also have to advertise this notice in the local messenger. So this notice was placed in the messenger. It will run through 2 cycles. So item number 1 of our open public meeting tonight is ordinance number 0-02-18, amending Part 2, Chapter 1 of the Code of the Walker County, Georgia, to comply with OCGA 36-1-29C, placing jurisdiction for the enforcement of county ordinances in the Magistrate Court of Walker County, Georgia, and correcting language regarding appellate review. So at this time, I'll turn the floor over to our County Attorney, Matt Williamson, and let him give us some background on this.
Thank you, Commissioner. A court's jurisdiction is the power of the court to hear particular cases. There are 2 kinds of jurisdiction that courts have. There's personal jurisdiction, which is a court's power to hear a case regarding a particular individual, and then there's subject matter jurisdiction, which deals with the court's case, or a court's power to hear particular cases regarding particular issues. When the Commissioner invited me on board earlier this year, one of the things that he wanted me to do as part of his administration's agenda was to review our code of ordinances and try to bring those up to date based on some history of not codifying them over the past 10 years. And so I undertook to review the minute books that are in the Commissioner's office to determine what the state of many of our code of ordinances are in. And one of those issues dealt with animal control. As you all will recall, earlier this year, we passed a new animal control ordinance, or an animal care ordinance. And a critical part to the enforcement of any ordinance is that we have some kind of enforcement mechanism through carrying those cases through a court system. To that end, I reviewed some of the code of ordinances regarding jurisdiction of our county ordinance cases, and in 2007 the prior administration passed an ordinance that gave concurrent jurisdiction over subject matter of county ordinances to both the state court and the municipal court, and the magistrate court of Walker County. However, as this opening paragraph of this ordinance provision states, Georgia law, specifically OCGA 36-1-20C, states that jurisdiction over violations for enforcement of such ordinances, meaning county ordinances, shall be as provided in Article 4 of Chapter 10 of Title 15, provided, however, jurisdiction over ordinances having to do with traffic offenses shall be in the court or courts having jurisdiction over state traffic offenses. What that means is that for all county ordinances except those which Georgia law specifically gives jurisdiction to state court, all other ordinance cases have to be resolved in the Magistrate Court of Walker County. To the extent that the ordinance passed in 2007 is in conflict with OCGA 36-1-20C, it's necessary for us to amend our ordinances to give only the Magistrate Court of Walker County jurisdiction over our county ordinance cases, which is what this first ordinance does. The second paragraph under this ordinance states, whereas an ordinance passed on the 18th day of October 2007, recorded at Minute Book 54, page 43 of the meeting of the Walker County Sole Commissioner, added sections 1-13 and 1-14 to Part 2, Chapter 1 of the Code of Ordinances to add regarding jurisdiction and venue and appeals, respectively. And whereas Section 1-13, subsections A and B of the Code of Ordinances places jurisdiction and venue for ordinance violations in either the Magistrate Court of Walker County or the State Court of Walker County. And whereas Section 1-14, subsection A, places appellate jurisdiction of magistrate court cases in the State Court of Walker County, And subsection B places appellate jurisdiction of the state court cases in the Superior Court of Walker County. And whereas jurisdiction for appeals of cases regarding violations of county ordinances are allowable only in the Superior Court of Walker County, be it hereby ordained by the Walker County Sole Commissioner that the Code of Ordinances of Walker County, Georgia be amended as follows, to wit, and then there follows the language of the amendment. The other aspect that is discussed in this change is appeals. If we have an ordinance case that gets heard by the magistrate court and the county prevails on the case, let's just say it's a dog bite case, or let's say it's an animal running at large, and the county is successful in proving that someone allowed their animals to run at large, and the magistrate court issues a judgment against the defendant and sentences that person to a fine of $150. That person has the right to appeal that case. Under the prior ordinance, the appeal would have been to the state court of Walker County. Earlier this year, in March and in April, I had a series of meetings with our state court judge and our magistrate court judges, and we talked through what the appropriate jurisdiction of each court was, and the state court judge accurately stated that appeals should not be had to the state court, but were only allowable in Superior Court. So Section 1-13, jurisdiction and venue, will now say that jurisdiction for any and all citations for ordinance violations, civil actions to abate nuisances, or any other legal action or enforcement measures arising under this code or under any other county ordinance or regulation shall be in the magistrate court of Walker County. Venue for all citations for ordinance violations and any other legal proceedings initiated by the county arising under this code or under any other county ordinance or regulation shall be in the magistrate court of Walker County. Any defendant who is charged with one or more ordinance violations may at any time before trial demand that the case be removed for a jury trial to the state court of Walker County. Such a demand shall be written. Upon such a demand, the court shall grant the demand. Failure to demand removal of the case shall constitute a waiver of any right to trial by jury which the defendant may otherwise have. That's an important point to remember as well. The state law does allow a defendant who is accused of violating a county ordinance to demand a jury trial. Because the magistrate court is not what attorneys call a court of record, that is, there is no court reporter, there is no written record of the court proceedings, the defendant has the right to request a jury trial, and it gets transferred to the state court, which is a court of record, meaning that all of the arguments by counsel, all of the evidence that's presented, and everything that happens during the proceeding in state court is transcribed by a court reporter and is kept by the clerk of court, such that if the defendant wants to appeal the case further on up the chain of appeal, that record gets transmitted upon the appeal. Prosecutions for violations of county ordinances shall be upon citation or upon accusation by the county attorney or such other attorney as the county governing authority may designate. Such attorney shall be the prosecuting attorney in cases tried upon accusation. Ordinance violations may be tried upon accusations or citations with or without a prosecuting attorney, as provided in OCGA section 15-10-63A. In the past, my understanding is that prosecutions of our county ordinances were being handled by a special solicitor whom the county hired in order to bring in have just on hand for the express purpose of prosecuting the county ordinances. However, for the time being, this administration is proceeding with just having myself as county attorney handle those prosecutions. Earlier this month, we had 10 cases on the calendar, and 8 of those actually were adjudicated. One of them, the defendant did not come to court, and one of them had a case that was still pending in state court that's in the process of being transferred, and that case was continued. So of those 8 cases, 7 of them were either guilty pleas or nolo contendere pleas, meaning that for the first time in a long time, we actually had a number of cases that were carried through to conclusion. So we're very pleased about that. Section 1-14, dealing with appeals. Unless otherwise specified by state law, any party wishing to appeal any decision of the magistrate court concerning an ordinance or any other provision of this code shall do so by certiorari to the Superior Court of Walker County, and such application shall specify any alleged errors of law or fact by the magistrate court. That word certiorari is a Latin-made word that's a term of art that's used in legal practice. All that word means is that in order for someone to appeal a decision to the Superior Court has to agree to accept that case. If the Superior Court does not accept the appeal of that case, then the judgment of either the magistrate court or the state court, if a jury trial is demanded, stands. It remains in effect. If the Superior Court of Walker County accepts the discretionary appeal, the Superior Court may set the case on the docket of the next available non-jury trial calendar or motions day. If the appellant has been levied a fine by the magistrate court, he or she must post a cash bond equal to the fine with the clerk of the appellate court. All ordinances and parts of ordinances in conflict herewith shall be the same and are hereby repealed. The Walker County Commissioner, and this says, took public comments at the Commissioner's public hearing on July 12th, which is today, and the 26th, which is our next meeting. At this time, I will be happy to answer any questions about this issue or about this change of ordinance. Thank you.
Matt, you did a very good job. That made it very easy to understand. Appreciate you taking the time to step through that. Matt has spent quite a bit of time working on this, researching this in the state law to make sure we get our county back into compliance. Also, as he indicated, has had several meetings with the state court judge and also our magistrate judge and staff to make sure we were handling things properly and had everybody understanding that this was going to be placed on the agenda, and make sure everybody had knowledge and would have the opportunity to make comment or whatever they felt like they wanted to do. But everything's gone really well, and everybody's seeming to be supportive of getting us back in compliance. Any other comments on this before we move to the next item? Okay, we will talk about this again on our meeting on the 26th, and so we will just table that item for now. There'll be no further action today because it's still running in the paper, and someone would have the opportunity to come in on the 26th, and Matt will go through and explain this again. So people watching by video may watch this and may want to come in on the 26th and make any additional comment or plea with this. So now number 2, we have an ordinance number 0-03-18. This is an amendment to the Walker County Soil Erosion and Sedimentation and Pollution Control Ordinance. And likewise, I'll ask Matt Williamson, our county attorney, to speak on this change of ordinance as well.
This one will be a little bit shorter because this is not an issue that directly affects the county ordinances. This is a much more straightforward type of change. The ordinance itself, the whereas paragraphs, make it pretty clear. The state of Georgia recognized Walker County as a local issuing authority pursuant to the Georgia Erosion and Sedimentation Act of 1975, and we are required as a local issuing authority to amend our county ordinances within 12 months of amendments to the Georgia Erosion and Sedimentation Control Act, and all of that is under OCGA Section 12-7, Section 1, and all of the following sections. And the changes specifically are set forth under the now therefore be it ordained paragraph and they are simply definitions that range from Section 6 to Section 18 of the Walker County Soil Erosion, Sedimentation, and Pollution Control Ordinance.
So again, these are just items that will get us in compliance with the state after they've made their changes, and we have 12 months, and so there's just a couple of clarifications, I guess, at the state level for definitions of a couple of terms. Any question or comments on these? Okay, as the same, we will continue that to the meeting on the 26th, where we'll have another public hearing and allow for comment and explanation on that. This time that will adjourn our special call meeting. We will move right into order of our July 12th, 2018 regular scheduled meeting. You should have a copy of the packet, and all this information is online. So you do have copies of our minutes. We had a special public hearing on June the 28th, 2018. We have those minutes there. Is there any corrections to those minutes? Hearing none, we'll sign those into the record. We also have our minutes from our regular scheduled meeting on June the 28th. Anyone have any corrections on those? Hearing none, we'll sign those into the record. Okay, under new business, we have a U.S. Department of Justice Office of the Justice Program Bureau of Justice Assistance Grant, or better known as the JAG program. Walker County has been awarded a total of $12,710 of this U.S. Department of Justice grant. Matt, would you like to make any comments on this?
Just very briefly, sir. I did review all of the paperwork, and this is a grant that is part of the Edward Byrne Memorial Justice Assistance Grant. Had some communication with Judge Thompson late last month. My understanding is that these funds will be used for our drug court. They are funds that have not necessarily specific requirements of particular programs that they have to go towards. It's much more in the way of restrictions that the monies cannot be used for. But based on my review of all of the paperwork, it appears that there is no problem with using these funds for our drug court. And as we discussed last month, that program is being very successful, and we certainly appreciate the efforts of everyone involved in that court and all of the work that they do. Mr. McConnell may have something to add. I understand you reviewed this as well.
I did. I think you covered it very well.
Okay, this is a $12,710 grant that runs through September 30th of 2020. There is no matching funds on this grant. This is a 100% funded grant, so we have no cash outlay. We just have to manage these funds and handle the proper accounting and disbursement of these funds. Is there any question, comment, or concern about us receiving this grant for Walker County? Hearing none, we'll sign and accept this grant. And as always, all of this documentation and detail is on the website. We won't go in, sit here and bore you tonight and read all of the fine print, but we do make it 100% available to you if you are up late and want to read that one night. Okay, item number 2, consideration of purchase order of Walker County Sheriff's Department requesting a roof system for the portion of the Sheriff's Office building. The Sheriff's Office, primarily the portion that's over the Detective Division, has got a very, very old roof that has been in very bad repair and maintenance for, I'm understanding, a period of at least the last 5 to 6 years. And they just keep putting a Band-Aid on it. And so this has progressively gotten worse. And so the sheriff had come to me and requested that we take a look at this and try to source a professional roofing company to do a full replacement on this roof. So we worked and ended up getting multiple bids on this, and the pricing was just absolutely all over the board, and the warranties and everything. So we ended up making a selection of Energy 3 out of Chattanooga, and they're going to install a .060 TPO roof system with a 20-year warranty with no deductibles, no exclusions, do all the proper installation, make it where we'll have walking pads to the air-conditioned units. And the best price that we were able to get was $22,500. We do have this in the budget in our capital expenditure items for major repairs to our facilities as capital improvement. But as we had passed an ordinance back October 2017, any out of the ordinary expenditures or capital improvements that are in excess of $15,000, regardless if they're in the budget, we bring those to the public meeting for public comment and public knowledge and disclosure of how we're spending the tax dollars of the citizens of Walker County, and let people know what major purchases or outlay of large dollar cash that we are making. So is there any questions about this? Hearing none, we'll go ahead and sign this purchase order. And again, there's no amendments to the change of the budget or anything. This is actually funding that was allocated for that replacement. Okay, number 3, Resolution R 20-18, declaring property of the Walker County Sheriff's Office as unserviceable surplus and removal from the county inventory. See Exhibit A. We have our standard resolution that we use when we remove property out of inventory. Sheriff Steve Wilson sent over a list of some older Motorola Droid telephones, Samsung Galaxy S5 cell phones, and one iPhone, and the appropriate corresponding serial numbers. So we've got 11 cell phones that they'll be surplusing out and selling those. I would assume probably on govdeals.com, and see if there was any value to those. It doesn't say that they're disposing of those to the landfill or anything. They would take and remove those from inventory and try to sell those. Any questions or comments on this inventory list? Here now, we'll go ahead and sign this resolution authorizing those to come out of the county inventory. Okay, item number 4 is our, I'm sorry, you're supposed to sign it, is our department statistical data for 2018. Should have that in your packet, and also is made available online. In the month of June, they were able to adopt or rescue, return to owners 80 dogs and 3 cats, and only had 1 dog that we had to euthanize. That met the protocol standards for euthanization. Code enforcement, there was 81 citations written for the month. They were able to close out 29 cases of getting properties in compliance, so that got our 2018 number up to 248 properties in compliance that were out of compliance. So we know the team and staff's been working hard there to get properties and get our property owners motivated to bring those properties into compliance. The fire department, emergency services, was very busy in the month of June. There was quite a few structure fires, unfortunately, in the month of June. Several of those were due to lightning strikes. So they were very busy with 606 total responses, and they were able to use 489 of those were with the quick response vehicles, so their activity was up quite a bit. Our roadside trash pickup that we focus on every day is 6,340 pounds of trash that was removed off of our roadside. We're continuing to get good results of the number of bookings at the Mount Cove Farm. The month of June, they had 78 overnight stays, coming off of probably the record month ever in the month of May of 181 night stay. So that puts us at 390 bookings in 2018. We were coming off in 2017 of 525. And back under the prior administration in 2016, they only had 162 overnight stays, and we're already at 390 for the year. So the staff there has done a fantastic job in promoting and good customer service and a lot of repeat business. Our single-family home construction continues to grow. We added 14 new single home permits in the month of May and 9 in June. That gets us up to 71 single-family home permits that have been pulled in 2018. Joe continues to do great on our public relations. He had 41 media impressions or stories that he was able to track. We added 204 new followers to the Walker County Facebook page, which is always good news. And Joe was able to post 40 Facebook posts in the month of June. We continue to get an overwhelming large number of traffic to our website at 24,746 visitors to our website. And we picked up 62 new subscribers to our e-newsletter that's sent out on a monthly basis. So that gets us up to 603 new subscribers in 2018, which is fantastic. Our patching potholes, I mentioned I think the last meeting that we were making some changes there. We were getting our patch truck going and getting it back in good shape maintenance-wise. We have a dedicated person now on that truck where we are 30 hours a week. We have a person that is trained in not only the operational of that truck, but also the maintenance and mechanical upkeep and repairs of that truck. And so Mike has started probably about 2 weeks ago, and I know he reported to me the other day. See, on Monday he patched 100 potholes in one day, and on Tuesday he did 119. So in 2 days he did 219 patches of potholes. So you can see how that compares to the entire month of June. There was only 162, and in probably by today in 3 days he did more than we did all last month. So you'll see dramatic improvement in getting our potholes patched, and we're using a different process than what they were doing. It should hold up much longer than the way we were doing that. Transit trips were 1,582, so that gives us a total of 10,692 transit trips. That just goes to show how valuable that service is to our citizens and our community, and we get a lot of activity and a lot of people that ride the transit. It's a very important part of our county government. Any questions on the statistic data? All right, that officially ends our regular scheduled meeting, and at this time we will open up the floor for any general discussion or comment that pertains to county business. And if you would come up to the podium so everyone can hear you, and also we can capture your comments on video. So who wants to be first? If anything, just come up to the podium one at a time, and any public comment, we'll be happy to hear from you. Okay, we've got, oh yes, you got
I was
something?
gonna wait and go last, but since no
Well,
one went.
you may be first and last.
I have a lot of questions this time that weren't mine. A lot of people messaged me this time that haven't been. So here we go. Is there a way that you can explain to people the jurisdiction on what the county is responsible for as far as paving and ditches? Are there roads in the county that aren't our responsibility to pave or mow, or all the roads in the county are our responsibility?
You have state highways that are the jurisdiction of the state. The easiest way to identify those are any roads that have markers on them that show a number, like Highway 136 is an example, 341, Highway 27. Roads of that nature are state highways and fall under their jurisdiction and also their maintenance. Any roads inside any incorporated city. So we have 5 cities within Walker County. A lot of people forget that. Most people are very familiar with City of Lafayette, City of Chickamauga, City of Rossville, City of Lookout Mountain, but many forget there is a portion of some residential area in the City of Fort Oglethorpe. And so anything within an incorporated area falls under the jurisdiction and maintenance of the city. So anything else outside of that in the boundaries of Walker County in the unincorporated area is jurisdiction of the county.
Gotcha. And what is your preferred method for citizens to report road and code problems?
The most effective way is to use the iWorks app that works both on Apple and Android both, because that captures that data and it goes directly into the system and creates a work order. So that gives a citizen 24/7 access at their convenience, and then they can articulate. And so it keeps from having any miscommunication, because they can see what they're reporting and it's not someone transcribing and trying to capture what they're doing. So that is the most efficient way to communicate. And then based off the selection of what type of issue it is, then it is automatically emailed and give notification that that work order is in the system to that department manager.
Perfect. If a citizen resides in Walker County but does not use Walker County water, will they be affected by the rate increase?
The rate increase that will be effective on August 1st of 2018 through the Walker County Water and Sewer Authority, that increase only affects those customers that are on that system. We don't have any influence nor control or oversight over any of the 8 water systems that service customers in Walker County. The Walker County Water and Sewer Authority is only one of 9 systems. So there is probably over 50% of the counties from a geography standpoint that falls outside of that. So it's only the authority customers.
While the rate increase was necessary to make repairs and improvements, are there any solutions being explored or looked into to help with the elderly and the very poor that are so afraid that they aren't going to be able to pay the extra?
Yeah. Our older citizens in our county, it's very important to me personally, and I think I can speak on behalf of the full board. It's very important that we don't let them run out of water. And we've had some very, very close days of the amount of inventory that we've had that was in the distribution system as a whole. And so we can live without a lot of things, but water is one of those things we cannot live without. And so my concern is that if we sit back like other water authority boards and leadership has done, have knowledge of problems and not address those problems, and we have a catastrophic failure that has been a known reportable issue, then we have not done those customers right, because a $4 increase is a lot. It's a big increase. We do acknowledge that. But if they have no water, one case of water will cost them more than $4. And so, just like on Tuesday morning, when the citizens inside the city limits of Chickamauga got up, they had no water. Their water system was offline. And so I was getting text messages at 6:30, 7 o'clock in the morning saying, what are you going to do about Chickamauga having no water? even though they have their own water system. Well, I didn't respond to those text messages because I didn't want to cause confusion and make it look like I was controlling that system. But I knew the leadership of Chickamauga knew all they had to do was turn 2 valves, and they would immediately refill their tank by pulling off of the Walker County Water and Sewer Authority system. They have 24/7 access as an emergency backup off of the Walker County system. So we are also in the process of getting an interconnection with Chickamauga where they can push us water if we go offline. There are some challenges with that. That's going to cost about $61,000 to make that connection. So when the engineering was done years ago, it was always, well, if Walker County needs to sell Chickamauga, that connection was made. But it appears that no one ever gave any thought to what about if Walker County needs water from Chickamauga. And so the pressure, the valving, the distribution was not set up but to send that water one direction. And so we are working to make that interconnection and should have that done hopefully within the next 60 days or less. That would give us some water supply. And it would supply the 2 large tanks there right outside the city limits of Chickamauga. There's 4 million gallons of storage there. And out of that facility, we are producing, filtering, and dispersing through the system about 2 million gallons plus a day. So based off of Chickamauga's capacity and also their permitting limits with EPD, they would be able, in an emergency situation, to push us somewhere between 200 to 300,000 gallons in a day. They do not have the capability to give us any more than that. And so that's why getting some is better than none. We are also making some upgrades and changing the pump system and putting in some variable speed pumps that would allow us to push water from the coke oven wells that we have in the county into that system as well, and also be able to take and push water from there down to the Kingsington Mountain Cove Farm area. So my concern is, if we don't make these improvements, and we've been operating so close to the edge, I don't want to have a room full of people that say, Commissioner, Water Authority Board, y'all had knowledge of deficiencies in the infrastructure. And for $4 a month, you could have fixed that. Now we're down. How many weeks are we going to be down? So it's very important for our elderly and older citizens that rely on water to live and survive, that we do everything possible to keep them from not having a water outage. And again, right now, it's a challenge for us to keep it going. It's a challenge. And so we would rather be proactive as a board, having knowledge of this information, fix the problems so they can budget for that $4 increase plus the $1.15 per thousand, instead of having to worry about stockpiling water supply or buying cases of water because of a risk. So there's a lot to this, and I know on the surface many people think, well, they're just going up on the rates to be going up, and we realize that this is affecting a lot of households between $5 and $10 a month, and if they're on sewer, it's twice that amount. But I would rather do that and do the right thing than to come up and have no water. So that's a long answer, but
No, you got it. And what is the status of the healthcare building in Rossville? Have we assessed anything inside of it to see if it's ready to lease again?
we got possession of that building back on June the 28th, 29th. They had agreed to be out by July 1, and they were. They did leave the facility in good condition. We are exploring a couple of other options that would benefit the low to moderate income in our community. And we are working through those options and working through some other providers that offer different types of services. And hopefully in the coming months, we'll be able to move forward and have something there that will benefit our citizens.
Recycling. There are a lot of people that are wondering if we're gonna go toward a county-wide type of recycling program.
Well, recycling is an interesting topic because recycling costs money. Recycling is not free. A lot of people think, well, if I'm recycling, you know, we shouldn't have to pay for disposal, but you still have the cost of the cans, transportation, labor, and everything to do that recycling. So my concern is if everybody got so upset about a rate increase on water, I'm not so sure we're gonna get people motivated to spend another $7 or $8, $10 a month to take part into a route system recycling. So if they are, we need to hear from the citizens that that's something they're looking for. But if everyone is to this standpoint, we can't handle any more expense, and I understand that, recycling will add expense. I have not seen or heard or found a program that was free or paid you to recycle. So there is a cost there. Some of the local cities have recycling programs. The city of Chickamauga has a recycling program, and you pay, I think it's around $8 a month for the opportunity to be able to participate in the recycling, to be part of a positive solution of not having to landfill those items. We do take recycling at the landfill, so people can bring their recycling items to the landfill, and there's not any cost at that point. But as far as a curbside pickup, there's labor and transportation involved that will drive that cost to have a provider come in and do that. But if that's what the citizens would like to see, we just need to hear from them.
And who would you recommend someone contact for wild animals on their property?
That has to be handled by the Fish and Game Warden, to my knowledge. Any wild animals, we do not have jurisdiction over wild animals. That has to be handled by the state.
Why are we building a new bus barn? Not my question, just gonna say that, but someone wanted to know why we're building a new bus barn.
The bus barn being built on Osborne School, or Osborne Road, I usually say Osborne School Road, but Osborne Road officially, there on the outskirts of Chickamauga, is a project of the Walker County School Board. And so the school board is governed by an elected school board members, and the superintendent, Dan Raines, is our superintendent there. So we don't have any interaction as far as local county government, as far as the governing body, getting involved in those affairs or how they manage or budget their money. So that question really needs to be answered by the school board or superintendent.
And the last one, did the county receive a $900,000 grant for the water system? And if so, what will that cover?
I would love to receive a $900,000 grant. I did sign the documents Tuesday night on a $500,000 grant that's from the USDA for emergency water issues. That grant was applied for last July. It's an emergency grant. We are very grateful for it. But it took the paperwork and approval process a year. And we still don't have the money. But we've been approved. So I'm not sure how much longer that will take. But that $500,000 will pay for this interconnection that I mentioned with the city of Chickamauga. It will also pay for the upgrades for the coke oven distribution system, that we'll be making those upgrades there. And it will also offset some of the cost of the rentals of those trailers, which will cover about 4 months rental there. So all the documentation, the representative, Tammy Decker, came up from USDA on Tuesday night, and presented all the details to the board. She had to be there to see any board discussion. The board accepted the grant under the terms and conditions unanimously because it's 100% USDA funded grant. There's no match on this particular grant, which is very unusual. Most USDA grants are 70-30, where the local government would pay 30%. But this being an emergency situation and it being a catastrophic issue that we had with our well, we met the qualifications and was awarded that $500,000 grant. So that's the only one in my tenure that I am aware of.
That was probably the one they were asking about.
Okay. Thank you. Good questions. Very good questions. Okay. Anyone else have any other questions, comments, concerns? All right. Well, we appreciate all of you coming out tonight. It's been a good meeting, and we look forward to seeing you in 2 weeks, and y'all have a safe travel home. Thank you.